Oh, okay, there we go. Okay, this is People of the State of Michigan versus Theodore Omer, docket number 22-388AR. And this is the time set for oral argument on the defendant's application for leave and motion for stay pending appeal. And if I could have first appearances of counsel.
Kayla Crino on behalf of the people.
Joshua Covert on behalf of Mr. Omer.
Thank you. Go ahead, Mr. Covert, then.
Thank you. So, Your Honor, I've received the prosecuting attorney's response to my motion for stay, and it got consolidated with the leave to appeal. When I look at this, I think they concede that Judge Allen made an error of law, and that he incorrectly determined that a moving violation causing death is not a serious misdemeanor. So it looks like what we need to really look at with the response from the prosecuting attorney is whether or not there would be reasonable cause for the sentence. I don't think, based on the transcript, for one, that we can say that without Judge Allen's analysis or insight. Secondly, it looks like the facts of this case. I don't want to be insensitive in any manner. There was a victim who died in this case. But when we look at every case involving a moving violation causing death, in every case, someone dies. And so I think there has to be facts outside of the elements of this crime that would substantiate a departure. And it looks like, what we look at is essentially the elements of the crime and that someone died. And that appears to be Judge Allen's reasoning, in that somebody passed away, and so I'm going to put you in jail. That's essentially the gist of what he did at sentencing. And I think that kind of ignores the legislator's intent when they created the new sentencing statute and made not a moving violation causing death a non-serious misdemeanor. Clearly, our legislators knew that every time somebody was convicted of that, there would be a death. So I think what we have to look at is what else occurred, what other than the death occurred. And in this case, as far as my client's actions go, I don't think there was anything more than the moving violation. We presented evidence that this was a medical instance, something that occurred with my client we're still trying to figure out. He said 2 unexplained accidents that caused injury, one to himself and the victim in the car crash, and then at work he himself had a serious injury due to a similar type of instance, which is all kind of talked about in the sentencing transcript. But so what I'm looking at in this case is that there has to be something other than the elements of the crime to substantiate the sentence. And in this case, I don't see anything other than the elements of the crime, and that there was a moving violation, and then unfortunately it caused the death of another. So and again, we don't have anything from Judge Allen on this, because Judge Allen, he got the law wrong, and he didn't want to. He even said at one point, "We're not going to argue about this. That's my decision," and so we kind of left it at that. So I think, presuming he would meet the rebuttable presumption, I don't think we can do one, and two, I think it's pretty easy to see that this wasn't a reasonable sentence given the facts of this case and the statutory framework we have to work in for sentencing. And so I would ask the court to grant the stay pending outcome of the leave to appeal, and figure this out, because currently my client's incarcerated, and if it turns out to be a wrong sentence, every day he spends incarcerated can't be made up.
All right, thank you. Ms. Carino?
Thank you, Your Honor. As my response indicated, MCL 769.5 does have a rebuttable presumption of a non-jail or non-probation sentence for misdemeanors other than those defined as serious misdemeanors. The charge of moving violation causing death is not a serious misdemeanor as defined by the statute. That is, of course, not the same thing as saying that this was not a factually serious matter. This was an incredibly serious and incredibly tragic case. It was, as we use the adjective, without question, serious. Our only concession on that point is that it does not meet the legal definition of serious misdemeanor from that statute. So based on that, there is a presumption that can be rebutted based on reasonable grounds. And it's our position that in this case, there were absolutely reasonable grounds to depart based on the harm that the defendant caused here. His actions killed Mr. Gibbs. His actions also could have killed Mr. Gibbs's 7-year-old daughter, who was in the vehicle at the same time, and appears to have only been spared serious injury or even possibly death based on where she happened to have been seated that day. This was an incredibly serious case. There was absolutely reasonable grounds for Judge Allen to give the sentence that he gave in this matter. The defendant's second argument in his application was that the probation was not tailored to the defendant, and therefore it violated another statute, MCL 771.3. This is also incorrect. It's our position that it was absolutely tailored not only to the defendant's risks and needs, but that it was also designed to reduce recidivism. And it, again, properly took into consideration the harm that was caused to the victim and also to the victim's family. And really, Judge Allen spent a great deal of time explaining why this is so. And things that he said, I think, are also important to consider when looking at whether the presumption for a non-jail or non-probation sentence was properly met and properly explained. He addressed that what rehabilitation actually means in the context of a charge like this. And I feel like that is, taking into consideration the circumstances here and the elements of the crime as well. That's a really difficult thing to do, but Judge Allen did a nice job of it. He took into consideration the defendant's past, things that the defendant had done before. He took into consideration the facts of this case. He took into consideration, again, the harm suffered by the victim and the victim's family. And in doing so, he crafted a sentence that was absolutely tailored to the defendant and also in compliance with the statute. As far as whether it's necessary to grant stay, our position is that is inextricably tied to whether there's any merit to the arguments in the defendant's application. No one, least of all the people, wants the defendant to serve jail time that under the law he shouldn't serve. But whether that's true is absolutely tied to the arguments that are raised in the application. And it's our position that because those arguments lack merit, assuming that the court agrees with that, there's really no reason to grant stay because the application and the motion for stay can simply be denied. But that's something that's certainly in the court's discretion, and it is largely dependent on the court's view of the arguments that are raised in the application.
All right, thank you. And Mr. Culver, did you want rebuttal argument?
Yeah, just briefly, Your Honor. Again, I don't think there's any question that Judge Allen got the law wrong. And I don't think there's any question that he created a rebuttable presumption. We're trying to infer that there's a rebuttable presumption from Judge Allen's statement during sentencing. And, I would argue that 75% of what Judge Allen said in this case, he would say on any misdemeanor case when he put somebody on probation. It's pretty standard language from Judge Allen. And so, again, we're really looking at the facts of this case and the elements of the crime. In this case, there's really nothing about the facts of this case that really differ from the elements of the crime. And the elements of the crime, as our legislators have said, isn't enough to put somebody in jail or probation for this type of offense. And I haven't heard anything about what my client did, his intent, or anything that he specifically did that day that made this any different than any other moving violation causing death. And with that being said, I don't believe this was a reasonable sentence. I think it violates the law, and we would ask for the motion to stay to be granted, and our leave to appeal be considered and granted as well.
All right, thank you. Well, I have to say, I do find it a little head scratching that the legislature did not classify this type of offense as a serious misdemeanor. But in any event, everyone is correct that Judge Allen did make an error when he said that this was under the statute classified as, or he appeared to believe under the statute, classified as a serious misdemeanor, because although the facts are serious, it is not classified under the statute as a serious misdemeanor. And what that means is that there is a rebuttable presumption that the court shall sentence the defendant with a fine, community service, or other non-jail or non-probationary sentence. However, the rebuttable presumption is not an extremely high hurdle to overcome, because what is required is reasonable grounds for departure. Judge Allen at great length spoke of the seriousness of the offense. Mr. Omer, through his actions, killed Mr. Gibbs and could have killed his 7-year-old daughter, who was in the car when her father was killed. Judge Allen put a lot of emphasis on the seriousness of the offense, and rightly so. I understand the argument that the death of an individual is already one of the elements of the offense. However, I don't think for one moment that the legislature, by saying that there's a rebuttable presumption of no jail and you can have reasonable grounds for departure, I don't think that they meant that because civil infraction causing death already has a death involved, that would tie the hands of the sentencing judge to ever overcome that rebuttable presumption. I just lost Mr. Covert. I'll pause and see if he shows up in my waiting room. And I also have Brooke's iPhone. I assume that would be someone related to Mr.
That is my, sorry, Your Honor, this is Kim Gibbs. That's my stepdaughter, yes.
I'm letting him in. Thank you. Okay, to the person who just joined us, thank you for muting yourself. I was in the middle of ruling when we lost the defense attorney. I'm waiting to see if he's going to call back in.
Okay.
Here he is. Okay, Mr. Covert, we lost you.
Yes, I apologize. I got a weird notice on my phone that said my phone was overheating and it shut down. I've never seen that before on my phone, so I apologize. I had an appropriate battery and everything. I don't know, but I think it's.
No problem. I stopped talking the second I realized you were gone. So okay, I don't think the legislature meant to tie the hands of a judge just because that a death is an element of the offense and that the judge could never overcome the reasonable grounds for departure, or never meet the reasonable grounds for departure just based on the death of an individual. I think what they wanted was a look at an individual case rather than an across the board kind of a rule. And Judge Allen looked at this case individually and this offender individually and put great emphasis on the seriousness of the offense, which I don't think that there's anything that says that just because that would be the factor that is the most compelling, that can't be the factor that you can use as reasonable grounds for departure. That makes no sense. Judge Allen put his reasons on the record. He spoke at length about the loss of Mr. Gibbs and the devastating and indelible impact on his family. And Judge Allen, in fact, provided reasonable, even though he was incorrect in believing that this was not an offense for which the presumption applied. Nevertheless, he was correct in putting reasonable grounds for departure on the record, and the sentence of jail was properly supported. The defendant also complains about certain conditions of probation, specifically, I believe, reporting probation and also no use of alcohol. Again, Judge Allen spoke at length about the purposes of rehabilitation and how his conditions of probation were aimed at rehabilitation. He explained that the no drinking or being in bars or places where alcohol is sold for consumption on site was intended as a rehabilitative provision of probation. He may not have used this word, but the word that we often use is that it's encouraging pro-social behavior rather than antisocial behavior. Antisocial behavior being something that, you know, if a person not convicted of a crime is consuming alcohol, that's fine, but a person convicted of a crime consuming alcohol could be considered not a pro-social behavior. But in any event, Judge Allen went on at great length, explained the reasons for these conditions specific to Mr. Ulmer. He indicated that drinking alcohol lowers inhibitions. One does not need to have a prior problem with alcohol in order to make it a valid rehabilitative condition of probation. And Judge Allen thoroughly explained his reasons for that. I didn't hear any specific argument about the reporting probation, but again, a perfectly valid and legitimate rehabilitative and supervisory condition of probation that allows a more focused and in-person supervision of the defendant, and certainly related to rehabilitation and engaging in pro-social activities and all the things that are required on probation. There is nothing legally infirm about Judge Allen's conditions of probation in this matter. And for all those reasons, I'm denying the stay and denying the application for leave to appeal and dismissing the appeal. And that will conclude our hearing. And I guess, Ms. Carino, you should submit an order.
I will, Mr. Covert, are you going to request the transcript? And if so, just let me know if you want me to delay at all in submitting that to the court, okay?
Certainly. Thank you.
All right, thank you. That will conclude our hearing.